Some quite often say that they possess a certain passion for justice, especially amongst those who describe themselves as social justice warriors, and in politics, perhaps you have too enjoyed the pleasure to have met quite a few. However, there is a great distinction between professing to possess a passion for justice and actually presenting a legal argument in a courtroom. And I've had the privilege to state with some pride that I have personally brought in just the past few years at least 9 cases all the way to the U.S. Supreme Court for docketing for certiorari. While the president has described me as somewhat passionate, description with which I would personally disagree, while the U.S. Attorney General has suggested that I am somewhat of a litigation hobbyist who has intervened in matters all across the nation, and most notably in a case presently before the federal courts, I found as opposing counsel a former nominee to the Federal Circuit Court of Appeals and the author of the Whitewater Investigative Report, James Lyon, representing the White House, a bit of a high-profile client, which had apparently outsourced to retain his legal services in a sole source procurement, and who is joined by Diana Zago Fassenbender, a partner specializing in high-profile better company cases for the international law firm of Orrick, Harrington, and Sutcliffe, LLP, representing the largest social media platform, Meta Platforms, Inc., owner of Facebook. My name, if you are not familiar, is Major Mike Brett. And if you doubt anything that I have said, you need only use your research skills to Google, a skill at which at least some are somewhat adept, and certainly proved the same a few years ago when I became internationally notorious. And for every action, at least in science, there is an equal and opposite reaction. But for the next few moments, let's talk a little bit about an intriguing topic now for the courts, namely the legal term of art, prosecutorial discretion, as it applies to a recent case in which I have become rather intimately involved. In 1989, the Virginia Supreme Court had held in the civil matter Buchanan v. Commonwealth that the Commonwealth is free to indict an individual for as many separate crimes as the Commonwealth in good faith thinks it can prove. And it is often stated that sovereign immunity is alive and well in the Commonwealth of Virginia. But this is a jurisprudential statement regarding the broad discretion granted to a prosecutor. However, as the U.S. Supreme Court had observed in Imbler v. Packman in 1976, even judges cloaked with absolute civil immunity for centuries could be punished criminally for willful deprivations of constitutional rights. And an intriguing case arising from events during what the former Virginia Attorney General Mark Herring had described as a once-in-a-century pandemic. Technically inaccurate because pandemics actually occur every 20 years, but characterized, at least in his mind, as threatening irreparable harm to an unknown and unknowable number of people, even though courts traditionally eschew speculation, and prompting the argument that the scope of the court's review must therefore be limited to a determination of whether the executive's actions were taken in good faith and whether there is some factual basis for the governor's decision that the restrictions he had imposed were necessary to maintain order. Citing U.S. v. Chalk, decided by the Fourth Circuit of Appeals in reference to the tumultuous civil disobedience occurrences that had been going on throughout the South even in 1971. Yet even that court had acknowledged that all power may be abused if placed in unworthy hands, and the courts cannot prevent abuse of power but can sometimes correct it. Relying upon the 19th century decision handed down by the U.S. Supreme Court in the matter Luther v. Borden. What do you think? We'd like to know. Brian Layla Porter, my newest adversary in litigation, and the Commonwealth Attorney for the City of Alexandria, has presented an intriguing argument now on its way from the Circuit Court for the city of Alexandria to the federal courts to decide in a matter raised on what attorneys might describe as a writ of mandamus, in which, as described by the Supreme Court's landmark decision of Marbury v. Madison, with which most should be familiar, during the early days of an in-short democratic republic, the officer to whom it is directed must be one to whom, on legal principles, such writ must be directed, and the person applying for it must be without any other specific remedy. What do you think? We'd like to know. And according to the Alexandria prosecutor, Brian Porter, even if many pundits have claimed that not even the president is a king, in fact, Don Beyer had mentioned that during the first impeachment, he has raised the argument that accepting arguendo, why we have to use Latin to sound intelligent, I don't know, but this was his words, as a pure hypothetical, that there was probable cause that the Alexandria mayor, Justin Wilson, had committed both murder and terrorism. Hypothetically, no court can order the Commonwealth's attorney to charge anyone, suggesting that the decision to charge a citizen is a discretionary duty, which lies entirely within the province of the public prosecutor. You agree with the statement? Or more properly, the question is that true? Does it depend on what party is being prosecuted, or who the prosecutor is? Is that an accurate statement of the laws of the Commonwealth in a rule of law that Attorney Porter has a constitutional duty as a constitutional officer to enforce? What do you think? We'd like to know. At least according to the U.S. Supreme Court in Jacobson v. Massachusetts, a case with which some should be familiar, the smallpox vaccine case decided in 1905 and rather often cited during the years of the pandemic, very rarely quoted, however. No power can be exerted to that end by the United States unless it be found in some express delegation of power or in some power to be properly implied therefrom. As my geometry teachers say, if it's not in the contract, you can't do it. And at least according to the authorizing statute in Virginia Code codified at VA Code section 15.2, 1627B, and describing the powers and the duties of a Commonwealth attorney, looking for all the words in the contract, Mr. Porter certainly has expressly been granted rather broad discretion in the prosecution of misdemeanor. That provision codified at the above section states that the Commonwealth attorney shall have the duties and powers imposed upon him by general law, including the duty of prosecuting all warrants, indictments, or information charging a felony, and he may, in his discretion, expressly prosecute Class 1, Class 2, and Class 3 misdemeanors, or any other violation, the conviction of which carries a penalty of confinement in jail or fine of $500 or more, or both such confinement and fine. What do you think? We'd like to know. My name is Major Mike Webb. By God, I am running for state legislature with liberty, excellence, and honor. Honest. This message was approved by Major Mike Webb. Honest.